If I have a will and a trust from Oregon and have moved to Washington, will my will and trust be honored? Short answer is yes, it will. Any estate planning document that was valid in the state where it was executed is valid in any other state. We know that if you have a will trust valid in Oregon, it's going to be recognized as valid in Washington, California, anywhere. That kind of begs the question, though. It's not whether it is valid, is it a good idea? Is it a good idea to have that estate plan that you had in Oregon and not do a new one in Washington? And the answer is, I don't know. You'll have to take a look at what is your situation. Go see an estate planner and an elder law attorney in the new state that you moved to, because you might find that there are really good reasons not to have a revocable living trust. Not uncommonly, people who move to Washington from California bring with them their revocable living trusts, because in California, probate is very expensive. It's fee based on the size of the estate, and you want to avoid the probate in California. How do you do that? You do that through a revocable living trust. In Washington, we have different rules, different laws. Our probates are much simpler and much less costly. But in addition to that, in Washington, if you want to protect assets for your surviving spouse against Medicaid spend down, then you should not have a revocable living trust. You should have a will that contains within it an asset protection supplemental needs trust. And that way, on your death, your assets will go to a trust that your will creates on your death through a probate for your spouse. And you might go, oh, probate, I thought I'm supposed to avoid that. Well, it depends on where you're at. Let's say you and your spouse have $1 million estate. On your death, everything is community. You want $500,000 to go to a trust that your will creates for your surviving spouse. That allows you to make sure your spouse will never become impoverished, because all of the assets in that trust are disregarded by the state Medicaid agency in the state of Washington. They don't count against your surviving spouse if they ever need the state to assist and pay for long-term care. So we know by a very simple planning tool, a will with an asset protection supplemental needs trust, we can protect half of the assets of this community. Whereas if we had a revocable living trust, we don't get that result. So that's like giving up $500,000 of asset protection because you didn't see an estate planning and elder law attorney in Washington when you moved here. So is it valid? Yes. Is it a good idea? Maybe, maybe not.